Welcome to Danforth Jewish Circle. About a third of the people who are joining us tonight are not DJC members, so welcome to our joyous, inclusive, accessible, inspiring, musical, and sometimes educational Danforth Jewish Circle. We're coming up for our 25th anniversary in 2022. You'll hear more about DJC throughout, and we definitely invite you to consider joining us, whether for individual sessions like this, or you might want to become a member. We'll tell you more about that. Here's a quick introduction of what we're doing. In just a minute, I'm going to introduce Rabbi Miriam. She's going to talk about the Jewish values at the heart of our approach to money and to giving, and how this applies during our lifetimes. And, oh, yes, there's that word, after our deaths. After Miriam has talked, Sheri Cohen has agreed to talk about why she has included charities like DJC in her will, and some of the challenges that she's faced in thinking that all through. Then we've got a good half hour for our lawyer and key person who will help us with planning your finances to maximize the benefit to your loved ones. There's a vowel missing, and the causes you support. We should have about 10 minutes at the end for Q&A, and we can go a little longer if we need to, but we don't have to end hard at 8:30, but that will be our goal, and then we can have a brief conclusion. So with that said, let me tell you about Rabbi Miriam. That lovely picture is the cover of her album. She has been rabbi at Danforth Jewish Circle since 2010. She teaches with the Institute for Jewish Spirituality. She's a member of the inaugural faculty at Ramamu Yeshiva in New York. Her album, This Is the Day, is a compilation of original compositions of music for prayer, and her melodies are sung by communities throughout North America, Israel, and Europe. She's also a co-founder of Encounter, which is dedicated to strengthening the Jewish people to be constructive agents of change in transforming the Israeli-Palestinian conflict. And she studied. She's a graduate of the Reconstructionist Rabbinical College, an alumna of the Wexner Graduate Fellowship and the Jerusalem Fellows of the Mandel Leadership Institute. She has an MTS from Harvard Divinity School and a BFA from York University. Rabbi Miriam, I'm going to turn it over to you now.
You know, a lot of people don't like talking about money, and a lot of people don't like talking about death. And tonight we get to talk about both. And I feel very honored that to bring a little bit of Jewish context to our conversation tonight, so that our reflections on what we own, the assets we have, and how we think about them in relationship to death and what extends beyond us, to have those things grounded in Jewish values and commitments. So let's start by saying the bracha, the blessing for Jewish learning, for the gift of being guided by wisdom. Baruch atah Adonai Eloheinu melech haolam, asher kidshanu b'mitzvotav, v'tzivanu la'asok b'divrei Torah.
Amen.
So the text that I want to look at, there's so many texts about the importance of using our money to support our money, our resources, to support those who are vulnerable, to support those who are in need, to build the community and institutions that are extensions of our values. But I want to look at this one particular piece and see how it might offer some framing. Scripture states elsewhere, so this is from a text called Midrash Tanchuma on a particular parsha, on Parshat Vayakel in the Torah. Scripture states elsewhere, a good name is better than precious oil, and the day of death is better than the day of one's birth. Quite a statement. They ask Solomon, why is a good name better than precious oil? He replied, when a person is born, no one knows what she will become. But when she leaves this world with a good name, good deeds become abundant because of her. Why is a good name better than precious oil? Precious oil is possessed by people of wealth, but a good name may be attained by poor and rich alike. A good name adheres to the living and the dead, while precious oil exists for the living alone. The scent of precious oil may travel from the sleeping chamber to the anteroom, but a good name travels from one end of the earth to the other. When precious oil falls upon a corpse, it becomes putrid, but when a good name is possessed by a deceased person, it does not deteriorate. When a child is born, no one can foresee the vicissitudes that may befall him, but at the time of his death, everything about his life is known. When Miriam was born, Miriam in the Torah, not me, no one was aware of it, but at her death, the well disappeared. This is referring to the well of water that the Israelites had during their time in the wilderness. So this text is referencing that when she died, the well suddenly ceased. And it was only then that they realized that they had water on her account because of her. When Aaron was born, no one knew, but when he died, the cloud of glory was removed. So as they were traveling in the wilderness, there was also a cloud of glory that provided shade in the hot sun and was also a direct encounter with divine presence. So that too, they enjoyed and benefited from, but it was only once he died that they realized that they all got to benefit from it because of him, on his account. When Bezalel was born, nobody knew, but before he died, he was called to build the tabernacle. After their deaths, everyone knew these things. So I want to say just a few comments about this very interesting text. This last paragraph that we were just looking at is an indication of the relationship between what we do with our lives and the benefit that comes to others from our goodness, from our commitments, from our values and our generosity. And in those references to Miriam and Aaron, in particular, before I get to Bezalel, I'll talk about him in just a second. It was only at their death that people understood how much they had benefited from their presence and their goodness. Death is a focusing moment. It's interesting that the text says that, when we're born, none of us know who we're going to become. When you have a child, if you have a child, you have no idea who your child will become. But death is a potent reflection. And as we talk about wills, I want us to keep in mind the question, who do you want to be at the end of your life? What choices are you making in your life now, and do you want to make in the future? So that what you have brought into the world is of profound benefit to others. And people can see that and will know that at the time of your death. The text opens, however, by asking us to imagine beyond just the moment of our death. And I'm so moved by this statement of a good name is better than precious oil. Precious oil here is representing wealth. Really, it is something that is for delight, luxury, and enjoyment. And a good name is worth more than that. And what exactly is a good name? Is it just about reputation? This line here, when a person is born, no one knows what she will become, But when she leaves this world with a good name, good deeds become abundant because of her. This sense of having a good name has to do with bringing our awareness and making conscious choices about the legacy that we leave after we've gone. For Judaism, there is this strong assertion here, at least in this text, that it matters very much that we live our lives so that the goodness that we do in this life actually continues and increases after we've died. So I want to offer that to the next part of our program tonight, to think about in what ways can we and will we choose to do that, to make the goodness that we are committed to extend beyond us and continue to impact people and move the world toward goodness after we have left this world.
Thank you, Rabbi Miriam. A good place to start. We're going to turn next to Sheri Cohen. Sheri has a background in social service work with a diploma from Centennial College and a BSW from Ryerson, who awarded her their Alumni Achievement Award. She's established the Sheri Cohen Social Justice Award for students with disabilities and learning disabilities at Ryerson. She's a founder of the Adult Learning Disabilities Employment Resource Center at Alder, co-founded the Learning and Violence Collaborative, and perhaps most important for our discussions tonight, she's made a study of wealth management with a focus on social change and philanthropy. She's a member of the Danforth Jewish Circle since 2006. I'm going to turn it over to you, Sheri. And I had a question for you.
Sure.
You've been really open about saying that you've included several charities, including DJC, thank you very much,
Welcome.
in your will.
Yes.
In addition to family. So what motivated you to include charities?
Well, for me, as somebody who grew up in a fundraising family came back from Winnipeg, and I've learned through the years that it's so important to gift in so many different ways, and gifts mean many different things to many different people. But I felt that in my will, as I started to plan my will a number of years ago, I thought, oh, what gives me joy? And what can I help to sustain going forward and to leave a legacy? So I decided to choose a number of different charities, and DJC being one of them, to gift in my will. And every couple of years or so, I change the amount. My will is a little different. I've decided to leave actual money instead of percentages. That's what I was told to do. But I felt like it was my civil responsibility and my responsibility as a member to really help DJC to move forward and to be sustainable well into the future. And that was really important for me. I feel that the charity piece is key and essential, and it was a joy to set up this for my will going forward.
Why in your will? Why not just give it away while you're alive and you can see the joy that it brings?
Well, I do that too. I do also gift as well, on a monthly or whatever it is I choose to do. But I think the will is important because for me, leaving a legacy of how the DJC has supported me through the years, and also to make sure that funds will be coming in to support the sustainability of the DJC going forward. I think it's a way to plan and to make sure that DJC goes into perpetuity in many different ways.
We're almost at the end of the counting of the Omer. I know that's been an important part of your spiritual practice as a reflection on the Jewish values of giving.
Yes. Well, it's interesting for me when I came back to Judaism back in 2002, and coming from my family and history, I couldn't figure out what was tikkun olam and what was tzedakah. And what did that actually mean in relationship to healing the world? You know, as a social worker, my work was basically on the ground and working in different communities and stuff. But I thought to myself, what does that mean in relationship to how do I become involved in the community that I'm involved in? What does that mean in the respect of leadership? How do I co-create with the DJC in our offerings together? I've often looked at, I have a very deep money practice where I look at, you know, what does gifting look like? When am I in the flow of money? What does that mean going forward? Also, I feel like for me, when I decided to gift in my will for the DJC, it's been very much of a, how do we support one another? And as well as how do we work together as a community, and all of the values that are in the counting of the Omar, like loving kindness and justice and discipline and compassion, is all part of the DJC. So that's been very supportive for me as I've walked this kind of practice for myself.
Sheri, for a lot of people, dealing with money, dealing with death, dealing with these long-term thoughts bring up a lot of emotional and psychological baggage. You've inherited money. You've given me permission to talk
Yes.
about that. And a lot of people will. We're in the midst of the great wealth transfer from one generation to the other.
Very true.
How do you handle all of the feelings?
It's complicated. It's complicated because I think, you know, it's interesting. I was talking to I belong to a group in the States called Wisdom and Money, and there are people who live with more than enough. And we often talk about what does that look like going forward in our lives when you know, for example, when I inherited money back in 1988, I didn't have to work. And when I started up my organization, I thought, oh, do I take a salary or don't I take a salary? What does that actually mean? Or what kind of skills as an inheritor do I need as I move in my life when people find out that I come from a background of wealth? The ask, it becomes 14-fold. And then how do I discern that ask? You know, when is money when do I gift from a place of flow? Or when do I give from a place of guilt? Or what comes up from that place of being able to say, you know, no, and that be respected. Also, I think too, as an inheritor, it's really different because it's me and my relationship with people, and then there's money behind that. So how to make sense out of that and to be able to be in conversations that are honest and open and transparent, you know, to be transparent, to be like open about that, and to talk about the issues, because money is considered a taboo subject. And I think there's an opportunity for growth in that respect, to be able to bring what isn't often named and taboo to the forefront.
Thanks, Sheri. One last question. You've
Sure.
put a lot of thought into this. What advice would you give somebody who's trying to sort out their financial planning, their legacies?
I think leaving money in a will is key to the DJC. I mean, for me, the first charity I decided to leave to was to the DJC, because of I wanted to see how I could leverage my life in a way that makes for change. And it doesn't make a difference how much money that is. I think it's important to be able to put in a will. It's there, and it's also movable as well. So if there's a place to kind of step in from and stay in the movement of what's transpiring through our lives, you know, our lives change, and I think that's the, you know, if I had one thing to do, and to make a suggestion is to leave funds in a will for a charity, especially the DJC. That's key.
Thank you. Thank you, Sheri. I really appreciate your openness and candidness about this on what for many people is a a pretty difficult subject.
Yes, thank you.
Let's turn to Robin Goodman. Robin is a lawyer. Whoops. She is Vice President of Insurance, Trust and Estate Planning Services at the Royal Bank of Canada, formerly an Assistant Vice President of Tax and Estate Planning at Manulife Financial. She's practiced law at Blake, Castles and Graydon, and she was a lawyer with the Ministry of Finance Ontario Tax Policy Division. So she's got the inside view. Her Bachelor of Laws from Osgoode Hall called to the bar in Ontario back in 1990. And she has written and spoken a lot of technical material that has been useful for lawyers and accountants across the country. Robin, welcome. You've been a member of Danforth Jewish Circle for how long now?
You know, as everyone was stating their years of membership, I was quickly calculating mine. I think it's probably 15 years.
Wow. Well, you've got some slides prepared. I'm just going to start off by asking you the deceptively simple and totally prepared question. Can you give a high-level overview of what people think about when they're starting down the will and estate planning path?
Sure. And Ken, you're going to be running the screen for me.
Happily.
So I will ask you, I just have a couple of slides to sort of kick off the conversation, and then hopefully we will have a Q&A. And I wanted to distinguish, I know we've been talking about wills and will planning, and really the will is the document, as we say, that speaks for you when you can't speak for yourself. That's the document that we look to after you are gone, when we want to understand what your objectives were as it relates to the transition of your assets. The will is a single document, but there's a lot of planning that goes into it and that goes behind it. And so that we typically refer to that planning not as will planning, but as estate planning. And for estate planning, we are talking about thinking about the transition of your wealth, starting from during your lifetime, through your passing, and then even considering the transition and where it's going to land and what it's going to do after you're gone. And Sheri talked a lot about that and talked about thinking about not just the giving that she's doing now, but the giving that she's going to be doing through her will and what she hopes that that wealth is going to do, particularly for DJC after she's gone for the long run. And that's kind of classic estate planning. Every family's estate plan is different, but we really do see a lot of common themes when we're talking about estate planning. So my way, when I think about this and when I'm talking to clients about estate planning, I always think about the big pie, and everybody has their own pie, and that sort of represents the wealth that you have. And the pie breaks down into many different slices. So for some people, we break out a slice. For everybody, we have to break out a slice for their lifestyle, what they're going to need during their life. Some people will make gifts to family members and to other parties also during their life. And so we want to break that piece of the pie out, and we refer to that as inter vivos gifts, or gifts that you're going to make during your lifetime. Some people include charitable gifts during their lifetime. And those three pieces of the pie generally, give or take, different sizes for different people, but those three pieces of the pie really represent kind of the amount of your wealth that you're going to consume during your lifetime. To the extent that there's wealth left over, that's where we start thinking about estate planning and legacy planning and tax planning, and that's where we look at what your will is. Tax planning is a big part of estate planning because there's a pretty big chunk of what's left over that's actually going to go to the government. And with planning, we really try to reduce that. I'm going to talk about that a bit more in a few minutes, but one of the most common and one of the best ways to reduce the amount that goes to government is to think about making charitable gifts at your death and through your will as well. So typically when we're looking at our wills, we look and we'll see, what are we leaving to the next gen? If there's a lot left over, we'll sometimes see multi-generational wealth transition where we're thinking about grandchildren and great-grandchildren, and sometimes structures even longer than that. And we will often see charitable gifts in the will. And all of that, when you combine together, helps us mitigate taxes and really helps us understand what we should be planning for during our lifetime that we can transition at our passing. So the next questions that we ask when we're starting to go through that, once we sort of understand what we're thinking, that there's a part we're going to need during our lifetime, there's a part we're hopefully not going to consume during our lifetime that we're going to transition through our will at our death. The next questions we ask are, what are the assets that we need to consider? What do you own? And many people have bank accounts and non-registered accounts, portfolios, stock brokerage accounts. Some people have registered assets that are RRSPs and RIFs and TFSAs. Some people have businesses and they hold shares of a corporation. Many people have real estate, and some people have more than one piece of real estate. And many people have life insurance. And when we gather that kind of basket of assets, each asset has a different tax attribute attached to it. And each asset has a different way that we can think about transferring it. So we really do want to break down the assets that you're going to consider and try and figure out which ones we're going to describe in our wills and which ones we're not. But before we even get to the describing the assets in the wills and which ones we do and which ones we don't, we have to ask the next two questions, which are, number one, what do we want to have happen to the assets? Do we want it to go to our beneficiaries? Do we want it to go to charities? Do we know which one comes first in terms of where it's going to go? And we'll see some people say that they want it to go to the beneficiaries, except charity can be used to help mitigate taxes. Other people will say that their charity is another one of their children. And if they had 3 children, then they want their will to be divided into 4. So different people have different views of how they want to break it down, but that's kind of it's charity, beneficiaries, and then, how much do we have to end up paying in taxes? Equally as important, and I will say that, as we have families with substantial wealth, and the last question is actually often the most important question of all, and that is, what do we not want to have happen with our wealth over time? And the typical answers I hear are, we don't want the kids to fight. We want to make sure that it's not going to get stuck in estate litigation. We don't want to tax to erode it unnecessarily. There are some taxes that will have to be paid, but most people will say they don't want to unnecessarily pay tax. And ultimately, they want to make sure that they have control over where those estate assets go. And the controlling the estate assets is an important thing. Then we look to say, how do we ensure that we have maximum control as those assets transfer or transition? And so this may be a pretty small slide for everybody to see, but generally speaking, the little figures in blue represent the assets that you can transition during your lifetime. So you could make gifts directly during your lifetime, either to your beneficiaries or, as Sheri talked about, to charity. We can make gifts indirectly during our lifetime, where we're not actually giving the wealth, but we're going to make sure that it's left our hands during lifetime, and that's through a trust. And we still think of that as lifetime giving, and any assets that we've even given away or put in a trust, those we don't have to worry about for will planning. We then look and we say, do you have RRSPs, and do you have insurance, and do you have other assets that we can name as a beneficiary, where it's going to pass to your beneficiaries at death, but it's also not going to go through your will. You can directly have those assets flow to the beneficiaries. Similarly, do you have assets that you own jointly with somebody else? Because we can also ensure that those will pass directly to a beneficiary and outside of the will. And once we have sort of carved out those assets, the remaining assets are the ones that we describe when we're talking about will planning. And so for our remaining assets, it's usually our homes, it's our portfolios, and it's businesses and shares of corporations. Those are sort of the traditional assets that we talk about when we're looking at will planning. And we will often have 2 wills, one that deals with assets that are subject to probate, and one that deals with assets that aren't. And I'll talk about that a little bit more as we go through this. Thank you. So finally, the final issues that we consider broadly when we're talking about will planning and estate planning are, do we have to think about taxes? And there are going to be taxes. I mentioned it 3 times or 4 times already, and you'll hear me talk about it a lot more. Taxes are a really big component of estate planning, and making sure that we mitigate and plan properly is one of the most important things that we can do through our will. And it helps reduce the taxes that we're going to pay, both in Canada and offshore. And in particular, if we have US tax liabilities, that's a really big one to worry about. So the wills allow us to deal and help mitigate taxes. It allows us to help protect against probate. We want to make sure that we have considered other things outside of our wills, like, are there cohabitation agreements that have an impact on where the wealth is going to go? Are there outside agreements like shareholders agreements? If we have someone who has a business, that we have to think about how this is going to impact on other shareholders. Do we have dependents that we need to support, that we need to make sure is covered off in the will? Do we have to worry about the rights of family members in other pieces of legislation? And one of the most important ones is spousal rights under the Family Law Act, where spouses have distinct and independent rights to portions of your estate under the Family Law Act, separate and apart from what happens in the will. And I'll talk about that again in a minute as well. And then finally, to the extent that we're making charitable gifts, can we use our will to ensure that not only are we doing tzedakah and making sure that we're giving to charity, but we're also mitigating taxes and doing efficient planning at the same time. And we want to ensure that ultimately we structure it in a way that the gift goes where we want it to go and when we want it to go. That can happen in a single shot, or we can structure it so that there's charitable legacy planning, where we know that it's going to be there over a period of time. And maybe there's going to be wealth that's transferred to the charity in different tranches and through different generations. Most importantly, we want to ensure that our will is structured so it protects us against intestacy. And intestacy is a big no-no when we're talking about estate planning and will planning. So Ken, I think that was sort of the highlight of the upper levels of what we think about when we're talking about will planning and estate planning.
So let's pick up where you just left off on the whole question of intestacy. What happens if somebody dies without a will? Who makes the decisions?
And I see Karen saying, what is intestacy? So good question. We're going to answer that question right now. So intestacy refers to somebody who has passed away without a valid will and without a will that speaks for them. And so you have all those assets that I've just described, but there's no document that represents your voice and that legally will transition your wealth for you. So if you die intestate, you die without a will. And what that really means is that the government decides for you who is going to receive your assets, and the government decides for you who is going to act as the executor to actually control the assets as they distribute out of your estate. So you still have assets, you still have an estate, but you no longer have control over where they're going to go, when they're going to go, and who's going to make the decision. So I'll give you an example. One of the most important rules of intestacy is that when somebody passes away, if they have a spouse, the spouse receives a prescribed portion of your estate, and then everything else is divided between spouse and children. It used to be that the spouse received the first $200,000 of your estate, and then everything else was divided. There was some new legislation that came in just last week, actually, and it bumped the amount up, or the preferred amount to spouse, to $350,000. So the spouse receives the first $350,000 of your estate. If you have other assets over $350,000, then those other assets get divided. If you have one child, regardless of how old that child is, they receive 50% of the other assets, and the spouse receives 50. If you have more than one child, then those children receive 2/3 of the other assets, and the spouse only receives the remaining 1/3 of the other asset. So that, by definition, gives rise to a whole bunch of issues. The first issue is that it requires taxes to be paid before you necessarily have to. So one of the rules of estate planning is where you leave your wealth to a spouse, the taxes that we're going to talk about in a minute don't actually have to be paid until the last to die of the two of you. If you die without a will, you lose control over when your estate has to pay taxes, and you're going to have to pay taxes for any amount that goes to anyone other than your spouse. You also lose the ability to decide when the kids are going to receive their wealth, because if you die intestate, they receive the wealth as soon as they attain the age of majority. If you die without a spouse, and a spouse, by the way, is legally defined as two people who are married to each other. So, and we can talk about that in a minute, but if you die without a spouse, then the law says that your assets go to your children. If you have no children, the law says it goes to your parents. If no parents, then to your siblings. If not, to your nieces and nephews, and if not, to next of kin. So you have no control. If you wanted to make any charitable gifts, there is no ability to do that. And there's no ability to plan for people who have disabilities, for people who may need some of the wealth held back over time. It's just set out at law.
Okay, so you make a powerful case as to why we should have a will, but you said a minute ago, sometimes people have multiple wills. Why would you do that?
We do multiple will planning for probate purposes. So probate is a process that we have to go through in Ontario. Manitoba used to have it. They just got rid of it a couple of months ago. BC has it, Saskatchewan has it. Some provinces do and some don't. And really, that is the process where we have to take our wills to the court and have the court stamp them so that when we as the executors take them to all the registered institutions to deal with, the deceased bank account and to deal with their real estate, those institutions know that I am truly the executor and they can rely upon me. And so the court stamps it and says, yes, this is the will everybody can rely upon. They charge a fee for that. And the fee is 1.5% of all the assets that are described in the will. The assets that are described in the will, any asset that's described in the will is going to be subject to this 1.5% fee. There are some assets that we need a probated will for and some that we don't. So anything that you own privately, for example, shares of a private holding company, shares of a business, where we don't have to take it to an institution, we don't have to take it to a third party. It's just a family business or a family holding company. If we put that in a will that we don't put through probate, then we're going to save the 1.5%, and we don't actually need it anyway for probate purposes. So it's really a probate planning tool. It doesn't change where things go, and it really isn't a whole lot of extra work. And anyone who has shares of any kind of a business or a holding company are always recommended to do two wills.
Let's jump ahead for a second. Tim's just asking, what about common law versus married? And you and I have also chatted about the special situations of same-sex couples who are living together. What happens in those situations?
So in those situations, it is all the more important to ensure that you have a proper will. Where we have someone who dies intestate, the intestacy rules, as I said before, are very specific as to where your wealth goes. It goes to a legally married spouse, or to children, or to parents, siblings, aunts, nieces and nephews, and next of kin. Nowhere in there does it say that it goes to common law spouses, whether you are in a heterosexual relationship or a same-sex relationship. So if you are a common law couple, then without a will, you're going to be subject to those rules of intestacy, and there's a very good chance that you're not going to receive an inheritance that your partner otherwise wanted you to receive. So it's very, very important to ensure that people who are in common law relationships actually have a will. The Succession Law Reform Act is one of the last pieces of legislation in Canada that doesn't actually contemplate common law relationships. So people in a common law relationship can have access to some support at the death of their partner through the Family Law Act and through dependent support relief provisions in the Succession Law Reform Act. But for the actual distribution of the estate, I want you to get my house, I want you to get the shares, I want you to get, my portfolio assets. If you don't have a will and you're in a common law relationship, you are going to die intestate, and your partner is going to have a heck of a battle trying to get assets.
And I've heard some very sad stories about common law couples where the parents inherited everything and basically kicked the partner out of the house on very short notice and said, I'm going to use this money to undo some of the damage my poor misguided daughter has done. It can be awful. We have about 5 more minutes before we're scheduled to go to questions. We'll see how many questions we have, but let's tackle this one. Let's say you've got a will and you want to change it or update it. Can you do that without visiting a lawyer? How does a codicil work?
Yeah, you never want to visit a lawyer, that's for sure. So when you're drafting a will, there are specific rules that apply in Ontario as to what has to be done to have a valid will. And a valid will can be one that is drafted by a lawyer. It has to be signed by 2 witnesses as well as by the person who's drafted the will. They all have to witness each other signing it. There's some affidavits. It has to be, there has to be a date on it, and you can't have writing all over it. It's very formal, and we call it actually the formalities of will drafting. You can do something that's referred to as a holograph will, where you write it all in your own hand. And if you do that, then we don't need extra witnesses. We don't need anybody. It has to just be all in your own handwriting, and it is still actually a valid and formal will. The concern is that you may miss some of the planning opportunities if you're going to be writing it yourself. But certainly if you're doing something quickly and you need to just jot something down as a holograph will, it is a formal will, and courts have given lots of thought to it. A codicil is something that you add when you have a particular provision of the will that you want to change. But in general and substance, the will still speaks to what you want it to speak to. So you may want to change who your trustee is. You may want to change one particular clause in your will and add a beneficiary, or change a beneficiary, or remove a beneficiary. And under those circumstances, you just add a codicil, which is just attaches to the rest of the will and only changes the one provision or one clause that you're wanting to change. You can do that by hand as well. I'm going to tell you that it's always better to have it drafted professionally. There is some art and skill in drafting it, but if you want to, if it's a last minute thing, you can always do it by hand. It just has to be entirely by hand.
There's a famous story about a farmer whose tractor overturned and trapped him. And as he lay dying, he wrote in the dust on the fender of his tractor, "All to wife." And the fender was taken into court, and they agreed that that was a legal holographic will.
Yeah.
Okay, it's been said most people pay more taxes the year they die than any other year of their lives. Why is that? And what can we do to make sure that more of the money goes to the family or your favorite charity instead of probate fees or taxes?
Yeah, so probate fees are 1.5% of those assets that go through probate. Taxes, on the other hand, you can't really sort of distinguish assets and say, I'm going to show this one to CRA and I'm not going to show that one to CRA. CRA looks at your assets and they impose taxes in two ways. If your assets are what we call capital properties, so portfolio, real estate, shares of a business, then CRA looks at the gain that is embedded in those assets as of a moment before your death, and they deem you to dispose of those assets. So they pretend as if you sold everything, and they make you pay, your estate has to pay the capital gain. Where you have an RSP as an example, they look at the value of the RSP, and if it doesn't go to spouse, or if you don't have beneficiary designation to spouse, actually, if we want to avoid the tax, then they will include the full amount of the RSP as taxable income. And so the reason I'm distinguishing it is because when we talked about probate, I said that's 1.5%. That's the tax that we have to pay, and that's to the provincial government. For capital gains purposes in Ontario, the tax effective rate right now is almost 27% of the gain. And if we're talking about RSPs and assets that get included in your income, right now the top marginal rate is 53%. And so there is, in one shot, a really significant amount of tax that might have to be paid by your estate. So how do we deal with that tax? Well, the first thing we do is we, number one, make sure we have financing to be able to fund the tax. So we have to make sure that we've got assets in the estate, and life insurance is one of the tools that we use a lot to make sure that your family can pay the tax, not have to sell everything, and not have to have a battle with CRA. The other way that we deal with tax, and one of the most efficient ways, is to make a gift to charity. When you make a gift to charity, whether it's during your lifetime or at death, $2 of gift wipes out $1 of tax. So if you have $100,000 of tax that has to be paid, you can wipe out that full amount of tax by making a $200,000 gift to charity. And really what you're doing is you're shifting what would have gone to the government to something that, for many people, they value more. And so that is a really, really efficient tool, particularly where we had people who say, I wanted to make a gift to charity anyway. And with some really interesting structuring, we can leave almost the same amount to the kids and leave a full amount to charity and eliminate or very much reduce the taxes that you're going to pay at death. So again, 1.5% for probate, 27% for capital gains, 53% for income inclusion, what we call income inclusion. So planning, making sure that we can defer it by leaving to spouse if that's where we want it to go, making sure that we can reduce it by making gifts to charity. That's what the will does for us. It really allows us to do that.
We've got about 10 minutes left in our scheduled time. Anybody who's got any specific questions, please pop them up and we'll deal with that. But we have some more questions. I want to mention that one person has noted that when we invited you to sign up, we said if you wanted to chat with any of us later, we would be happy to talk with you. Not giving away Robin's time, but I know a few things about this. I'm happy to talk with you. There's no fee. It's not a substitute for legal advice. I'm not a lawyer, but we can certainly have a general chat to help answer some additional questions for you. Tim is asking, is there a limit to inter vivo cash gifts?
So I'm going to give you a true lawyer's answer, and I'm going to say it depends. In general, no. You can give away whatever you want to give away. The issue that we worry about are the tax consequences. And so the things that I would be looking at if I was thinking about making an inter vivos gift is from a tax perspective. Number one, do you have to pay tax to liquidate the asset to give it away? Because you don't always want to pay tax to make a gift. So we would want to look at the most efficient asset to make a gift. And if you have cash, well, that's the easy asset to make that inter vivos gift. And inter vivos, again, reminding everybody, means you're making a gift during your lifetime. That's what an inter vivos gift is. If you are going to be making a gift to a spouse or to a minor child, then for tax purposes, we have something called attribution rules. And those attribution rules will sometimes take the tax on that money that's been invested in their hands and attribute it back to you. So you still pay the tax. May not stop you. It may be ultimately you're making a gift because you want to be making a gift. But we do want to think about the taxes associated with that. If you're making a gift to someone who's in the US, then they have their own set of rules, and their rules are very strict as it relates to gifts. You can gift any amount that you want to somebody in the US, but they have to just notify the government that they've received a gift from you. And so there are different things that you have to think about when you're making a cash gift to someone during your lifetime, not the least of which is if it's to your children, are they old enough? Are you feeling comfortable enough that they're ready to receive the gift? If we're talking about making a gift during lifetime to charity, that's not typically what we refer to as an inter vivos gift. That's a lifetime charitable gift. There is no limit as to how much you can give. For tax purposes, you can wipe out up to 75% of your taxes in a year during your lifetime, and you can carry that gift forward for 5 years. At death, you can wipe out 100% of your taxes. So again, you know, there's taxes and then there's real life. And Sheri talked about it before. You know, you want to make a gift during lifetime because you want to see what's actually happening to it. And so even if you might not be able to be as tax efficient with it, a lot of people look at doing it.
Robin, one of the biggest barriers to people getting on with this is having to talk to their families about it. What guidance can you give people about having that conversation?
Yeah, it's a tough one. And I talk to people every day about this. And there are lots of different reasons why people struggle with talking to their families about the transition of their wealth. Some people, it's just taboo. And they just, you know, as Sheri said, it's hard to talk about money. It's a taboo subject. Talking about death in many cases can be taboo. To the extent that there is going to be a substantial amount of wealth left over, and everybody has their own definition of what that is, it really is important to talk to your families at some point. It's important for them to understand what your values were so that they understand why you made the gifts that you made. If you're making gifts to charity, it's really important for them to understand why you did that. What you don't want is for them to challenge this after you're gone, because you're not here to explain what it is. You want to explain why you made the decisions that you made. You know, we see lots of circumstances where people make unequal gifts or choose to not make a gift to a particular family member, you know, the black sheep of the family, as they say. And under those circumstances, it's all the more important to document somewhere why you're making the decision that you're making. Because what you don't want is for that person to hold up the estate and the transition of the wealth because they're taking it into court. So you want to have a note somewhere that says, I understand that I'm cutting out my son or my daughter. I'm doing it on purpose. I'm doing it for the following reasons. And you want to be able to ensure that nobody thinks that you were persuaded to do something that you weren't in your right mind to do. So communicating with your family about what you're doing is really, really important.
We've just got a couple of minutes left. I've got two quick questions for you. Michelle Brown wants to know, Robin, do you offer services to individuals or is your work just corporate? Any recommendations for professionals who could help with estate planning in a formal capacity?
I'm going to answer that offline, I think. My work is through RBC, so I don't have private clients, if that was the first part of the question. We can talk further about how I can help and who I can refer you to. There are lots of really, really great estate planning lawyers out there, and depending on your circumstances, everybody has their own area of specialty. So we can.
And I want to emphasize somebody who has that as a specialty. Somebody may be fantastic at real estate law or corporate law. That doesn't mean they understand wills and estate law.
I always tell everybody a real estate lawyer is not a real estate lawyer. We have to find the right lawyer for you.
We have 3 minutes left to 8:30, but our time allows us to go on and continue the discussion for those who want to stay. Sybil is asking, is there a difference between the tax benefits from charitable donations while you're living and when you leave it in a will?
Yeah, and so while you're living, you can wipe out up to 75% of your taxes. If you leave it in a will, then you are able to actually wipe out 100% of your taxes in the year of death and the year prior. So it's where it's a big part of the planning that we do when we're talking to people is we try and figure out where is your biggest tax liability going to happen. And if we're thinking about charity and we know that you're going to give it during your lifetime and at your death, if I look and I see that you're not going to have a substantial tax liability at your death, then maybe I would recommend that you fast forward the gifting and start giving during your lifetime. A, you get to watch it and you get to see what happens, but B, it'll allow you to reduce your taxes annually and have more money in your own pocket and not waste the tax benefit of making the gift. So that's the first thing I would suggest. The second thing I would say about the charitable gifting is depending upon what asset that you gift to a charity, there's also some additional tax benefits there. So if you're going to be gifting shares, portfolio shares, publicly traded securities, you get an extra tax benefit by wiping out the capital gain in that share, as well as getting the tax receipt for the amount that you gifted. And so to put it, simply, if I had a share worth $10 and I had a $5 gain embedded in the share, under normal circumstances, I'd have to pay tax on that $5 gain. If I gift that share to charity, then I don't have to pay tax on the $5 gain. And I get a tax receipt for $10 that I can apply against other taxable income. So it's a really efficient way of making a gift.
So let me just underline that. If you have stocks, don't sell them and give the money to charity. Give the stocks to the charity. It's a better tax break.
Correct.
Life insurance and other kinds of insurance. We haven't talked much about that. And some of us have insurance that we bought for kids that have grown and we don't need it, or for a spouse who's not around anymore. Can you talk to us a little bit about insurance as part of the estate planning and as giving to charity?
Sure. So when we talk about insurance as part of estate planning, we talk about it in a couple of different ways. Some people think about insurance and they say, I need it temporarily because my kids are young, and if something happens to me, I need to be able to take care of them. And so that's a kind of insurance that you would typically see that's there for a specified period of time. It's referred to as term insurance. And it's probably not the kind of insurance that we think about when we're talking about estate planning per se. It's more protective insurance. There is a kind of life insurance that we refer to as permanent insurance, and permanent insurance is insurance that is there for not just if I die within a specified period of time, but when I die, I have some liabilities or I have some gifts I want to make. And that we use that insurance to cover off whenever death happens, if it's 120 or at 80 or whenever death actually happens, that insurance is going to be there. We don't have to worry that it's going to be gone. That insurance is an asset that is tax sheltered. And so when we're doing estate planning, we will often say to people, one of the things you might want to consider is, first of all, if you have existing insurance, you might as well keep it. if you bought it for one purpose and it's still there, you can keep it and it'll be an asset of the estate and you can use it to help pay your taxes. You've already paid for it in many cases, so you might as well keep it. Even if you have to continue paying for it, it is tax sheltered. So you're going to put wealth into it and then you're going to put in X and you're going to get out Y. And the difference between what you put in and what comes out is tax free. So maybe you look at it as an asset. If you decide, of course, my phone's going to ring right now. If you decide that you don't want to keep it or you want to make a gift to charity, it's actually a wonderful, wonderful tool to give to charity. We can either designate the charity as the beneficiary. And if you do that, then the death benefit, the amount of those insurance proceeds, creates a tax receipt for your estate. Alternatively, you can actually gift the policy to charity during lifetime. And if you're going to gift the policy to a charity, charities love it. Synagogues love it because they have control over the policy. They know they're going to get those proceeds at death. And during lifetime, when you're paying the premium, you're actually getting a tax receipt every year for the premium that you pay. So you're really only putting in half of what you actually have to put in. So it's a tool that we see a lot of people use. Sometimes they use existing policies. Sometimes they go out and buy insurance specifically for that purpose. There's a big push right now in Toronto in the charitable community to look at insurance as a gifting tool because it's so efficient for the giver, and the charities love it because it's guaranteed money for them.
And there's one more piece. You know, when you get a job, sometimes insurance is part of the benefits package. A few years ago, I took a job with a charity and I already had my life insurance in place. So I didn't really need the additional insurance that came with my benefits package. So I made it payable to the charity where I was working. There were days when people walked by my office door saying, is he worth more dead or alive?
Yeah.
Of course, eventually I left the job and the policy expired, but had something happened to me while I was working there, there would have been some money to cover the transition.
Yeah, exactly.
Tim has asked, what if I sell my house and give the money to my children? And I guess I'd add in, well, your principal residence or your cottage, two different questions.
Yeah, the principal residence exemption is a rule in the Income Tax Act that applies to the property that you own that you designate as your principal residence. And there's rules around which property that could be. It could actually be your cottage or it could be your home. And we typically look and we say, which one has the biggest gain? Because the benefit of designating a property as your principal residence is that when you sell it, you don't pay tax on that gain. It's one of the last remaining tax shelters that we have in Canada. Principal residences and insurance are really the two that we have right now.
Although there's some talk about that changing.
Yeah, yes, there is. And so if you're going to sell the principal residence so you get the proceeds from it and you don't have to pay tax on it, now you have cash. Now that's part of your living estate, I guess, as we would call it. If you want to make a gift of those proceeds to your kids, by all means do. As I said before, you want to think about if the kids, A, are old enough from a family perspective, but from a tax perspective, you just want to make sure that you're not going to be creating attribution. And if your kids are in the US, it's an entirely different conversation.
Someone was just asking whether DJC accepts gifts of shares. DJC has received gifts of shares, and we're looking into improving our systems so that we can do that more effectively in the future. One of the common practices is when a charity receives the gifts of shares, they sell them right away so that they can crystallize the value. You get the value at the moment of transfer. If they go up or down, it doesn't affect, it's at that moment, what were they worth? And DJC is going to try and sort out how to handle that much more effectively in future. What about, Robin, people who don't have much right now, but they sure hope to have more in the future? Is that one of those places where giving a percentage of your estate makes more sense than saying, I'm going to give X dollars? Because my house right now is worth a whole lot more than my house was just a few years ago. If I had said I was going to give $10,000, inflation might wipe out that and might not seem so exciting.
Right. So, I mean, one of the nice things about will planning is that what you put down in your will doesn't actually crystallize until your death. And so we recommend, in the old days, when I first started practice 1800 years ago, we used to tell people every 10 years, you got to make sure that you look at your will and look at your estate plan and really make sure that it's doing what you want it to do. Things have changed a lot. The world changes really quickly now. And so we tell people every 5 years, every 3 to 5 years, take a look at your will. And so my recommendation is, when you're drafting your will and when you're thinking about charitable giving, think about it as if it had, God forbid, it had happened yesterday. And think about it based on what you have right now and where you want that to go. And if your circumstances change, review your will and look at it differently at the time. Because as you say, Ken, a particular amount today may seem like a big amount. Many years from now, either it's a small amount in the context of what's now a much larger estate, or because of inflation, it's a different conversation altogether. So in any event, you're going to want to be reviewing your will. And I would suggest do it as if today were the day, and do it exactly the way you want it today. And we can always review it and change it.
One of the challenges is getting an executor. How do you decide who should be the person or organization? Maybe you want your bank or your lawyer to do it. Maybe you don't. There's problems with that too. It can be expensive to hire somebody to be your executor. How do you choose?
So I'll tell you, being an executor is the greatest honor and the worst responsibility. It's a really, really tough job to be an executor. You have to understand about the assets. You have to understand about the family politics. And for most of us, we have full-time jobs. And it's a big, big job to be an executor. So when you're trying to think about who the executor of your estate is going to be, you want to think about what are you asking them to do and how much work is going to be involved in it. And so if you have a complex structure, you got lots of businesses and lots of corporations, you need somebody who has the business acumen to kind of deal with that. You also need somebody who has the time and the availability to deal with it, because it's, as I said, it's a pretty big job. It's a pretty onerous job. If you have trusts in your will that are going to be there for a while, so you have young kids as an example, and you decide that you don't want to give them everything until they're 30, 35, 40 years old, you need to think about the ages of your executors, because if your executors are your age or older, they may not be around long enough to, or be capable long enough to actually do what you're asking them to do. So thinking about the executors is a pretty big decision. You can change them. Every time you change your will, you can change your executor, but it's not something to take lightly. So my recommendations are, if you think your kids are going to get along and you think they're old enough and everything's going to go to them, then we sometimes do see people say, my kids are going to be the executors. It's all going to them anyway, and they're old enough to deal with this. If you don't think that's the case for any reason, then I would recommend looking at outside people, and a trust company is always a great option. Yeah, you have to pay them, but they are not influenced by family fighting. They have people who do this all day. That is their full-time job. And they understand the business of money and the money of business and all of that. So that's always a good option to think about.
Speaking of changing your wills, divorce, remarriage, these are key moments in sorting out the will. Also separation, which may not be legal. What if you hate your spouse, but technically you're still married, and should you die, they still inherit? Oh my.
Well, it's funny, I actually didn't know you were going to ask me this question, but legislation changed about a week ago. And some of the changes actually have an impact on some of what you're asking. So it used to be that if you got married, your marriage automatically revoked your will. And we always told people that you have to, there's a special clause you have to put in the will that the will should survive even once you get married. So that rule has now changed. And if you get married, your will doesn't automatically get revoked, which is a good thing if the will said what you wanted it to say. Not a great thing if it didn't, in that you actually have to remember to go back and change the terms of your will. And so a marriage is one of those life events that automatically we're going to say, let's look at your beneficiary designations, let's look at your assets, let's look at how you hold things, and let's look at your will to make sure that it does what you want it to do, and that the people making the decisions, your what we used to call executors or estate trustees, they are the people who are most appropriate now given your new life. I'm going to say the same thing if there's a divorce. Divorce is a life event, obviously, that is going to require you to think about all of your assets and where they go in your will. The law also is now changed so that if you are divorced, you are treated as if you predeceased, as if the person you divorced or your ex-spouse predeceased you. So even if you forget to take them out of your will, there's now a mechanism that actually removes them. I wouldn't count on that. I would count on it in that it's law, but I don't want to rely on it. You want to actually think about where you want your wealth to go and not just where you want it not to go. So you still want to review your will anytime you're going through a divorce. Separation is a little more complicated because, as you said, in many cases, you're still legally married. The separation rules also just changed and is now a little more flexible. So if you are legally separated and you pass away before you're actually divorced, then the courts can remove your separated partner from the will, and they no longer have the right to make a claim as a dependent, as an example, and they no longer have the right to make some of the claims that they otherwise could make. There is one piece of legislation I do want to just kind of alert everybody to, and that is the Family Law Act. And the Family Law Act says that if you were married and you passed away, then your spouse has 6 months to decide whether they want to take what you left them under your will and life insurance and everything else, or whether they want to make a claim under the Family Law Act as if you were divorced. And you would go through that, they would go through that whole equalization structure and have to figure out who owes what to whom. And so there's a calculation, a financial calculation that some people go through to decide where it's better for them. That's something always to think about when you're thinking about leaving your wealth, and in particular where you've got a second marriage. Because where you have a second marriage, we will often hear parents say, I want everything to go to my kids, and I leave a little gift to my second spouse, but really, that's not the parent of my children, and I want everything to go to my children. That second spouse has rights under the Family Law Act, unless you do something in particular to protect that. So if you want to do something and you think that you don't want everything to go to your spouse or 50% to go to your spouse, and as I said, most commonly we see it in a second marriage situation, make sure you have an agreement or a marriage contract, because that is going to help mitigate a lot of the rights that spouses have through legislation that's different than just the legislation that arises through intestacy at death.
This is perhaps why you need a lawyer, somebody who knows that the law has just changed and can sort out all this stuff. Either you don't want to leave your second spouse money, or you definitely don't want to leave money to your ex, or maybe you have a relationship with your ex and you do want to leave them some money. You need to think through what you want to do, but you need to make sure that it is written clearly enough so that it holds up.
Yeah. As I said before, a real estate lawyer is not a real estate lawyer, and everybody has their area of specialties. And an estates lawyer is, really is on top of all these things, because these rules change all the time.
Let's go back to the trust company. Michelle wants to know how fees are determined if a trust company is managing the estate as executor.
Different trust companies have different fee schedules. Most of the time, what they're going to ask is that you actually agree to the fact that there will be a fee schedule, and you put that agreement in your will. Their fee schedules change, but it's usually a percentage of the assets that they're going to manage. And in some trust companies, it's on a sliding scale, depending on on the quantum of the assets. Different for different companies. And I would encourage anyone who is thinking about a trust company to talk to a couple of them, because you'll get a sense of what their rules are. RBC has a really good one.
Another shameless plug. Fair enough. Fair enough. Can somebody who is a client of RBC Wealth Management get you to help them?
Yes.
Yes. There's the answer.
There's
We've covered a lot of territory. Is there anything else that we should touch on as we wrap up for tonight?
Yeah, I'm going to add one thing, and this is the thing that I spend most of my days and nights thinking about and has made me go prematurely gray. I'm actually only 17, but since I've been looking at families who have beneficiaries in different jurisdictions, it's made me look like I'm in my mid-50s. So where you have beneficiaries in different jurisdictions, it is all the more important to have proper estate planning. Where you have beneficiaries or family members who are in the States and you're going to be leaving wealth to them, they have an estate tax that applies on not just the gain in your assets, but on the full value of your estate. And if you're over the threshold, that estate tax is 40% of the value of your estate. So when we're leaving assets to people in the States, we want to put them in special trusts so that we can protect those assets so that they're not taxed in Canada and then taxed again in the States. The UK has similar rules. They have an inheritance tax. And so we want to be mindful not just of the rules that apply in Canada as we are giving the wealth away, but we want to think about the rules that apply in the jurisdiction where our beneficiaries who are receiving the wealth live.
And that's just if you have children living in the States or the UK. An added complication is that a person might be a dual citizen themselves. They might have income from the States. And what about transitions across Canadian borders? What if we have kids or family in Quebec or BC?
Yeah, it's not as big an issue. We have probate concerns. And we have concerns, family law is a little bit different there. So there's bits and pieces of legislation that are slightly different, but that's not as big a concern. The concern more is multi-jurisdictional across our international boundaries.
Does it make a difference whether the family members are living in the States but not American citizens?
Yes and no. If you're living in the States, but you're not an American citizen, then while you're living in the States, you're still subject to some of those tax rules. If you're an American citizen or a dual citizen, as you described, then you are absolutely subject to those rules. And we have to do some really specific planning for them. Even if you live in Canada, have no beneficiaries in the States, but you have US situs assets, then we have to think about that because we can have US tax apply to that as well. So in particular, where we have any connection to the States, that's where it makes us old and gray as we're trying to figure out how to plan for you.
Michelle's just asking whether it's necessary to hire a special estate lawyer when there are children with disabilities. I would expand that slightly because it could be a spouse with disabilities, parents with disabilities.
Yeah. You definitely want to hire an estate lawyer. You definitely want to talk to someone who understands. Most estates lawyers understand disabilities and disability law and how we gift and the vehicles that we use to gift. And for disabilities, we want to think about two things. One, we want it to be tax efficient. And I'm actually saying these in the wrong order because the truth is, number one, we want to make sure that it is going to be there to benefit the person, and that we have the proper controls around it so that nobody else can get their hands on it. And if we're worried that that person is going to go through it, that we have control so that they don't get their hands on it. But there are also all kinds of tax relief provisions that the government has put out for people with beneficiaries. And we want to take advantage of that. So to the extent that, we can play within the Income Tax Act and maximize the benefits that the government gives us to help us take care of our family members with beneficiaries, that's what we want to do. So yes, you need a special lawyer, but you don't necessarily need a lawyer who specializes in disability law. You do need an estates lawyer.
And somebody just pointed out it could be a sibling with a disability just as well.
Right.
We've covered so much territory. Robin, there's a whole bunch of people in the chat room who are saying how informative you've been, but I think we may want to do this again sometime soon. If you would like to discuss this in private, you can email info@djctoronto.com. That'll come to me and I will chat with you or see what else we can do. A special thank you to Robin and Sheri and Rabbi Miriam. And a shameless plug, Danforth Jewish Circle's 25th anniversary is a great time to consider special gifts to secure the next 125 years and beyond. And if you're interested in knowing more about Danforth Jewish Circle events and services, you can check with djctoronto.com. And just because DJC has a tradition of closing with a joke, a new Yiddish word, oigezumt, overexposed, fatigued, exhausted, bored, had it with Zoom, as in, ich bin a zoi oigezumt. Or as they say in the old song, Zoom gali, 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 Zoom gali, gali. Thank you. Let's call it a night with many thanks. Bye, everybody.
Bye.